My testimony today will rely on my experiences as an assistant U.S. attorney, a criminal defense lawyer, and 30 years in the Navy JAG Corps, where I retired as a captain and served for 5 years as a military trial judge. First, I want to make three interrelated points. First, unlike all federal and most state court judges, immigration judges cannot dismiss a case for failure to state a claim. Second, immigration judges cannot render judgment on the pleadings, even in patently frivolous cases. And third, even though Congress passed a law 26 years ago giving immigration judges contempt authority, no administration has actually implemented that rule, which means immigration judges don't have contempt authority. The bottom line is this: immigration judges, wherever they're housed, must have these common judicial tools to manage their crushing caseloads. Let me put a finer point on it. You've heard that there's over 2.6 million cases pending before the courts. That's up from 876,000 in 2019. If Congress does nothing and deprives immigration judges of the common judicial tools, their caseloads will climb into the millions. But if you give them 12b-6 authority and the ability to render a judgment on the pleadings and then arm them with contempt authority, their caseloads, by some estimates, would be cut by 75%. This is not and should not be a partisan issue. This is a good governance issue, as the judge said, pure and simple. My first point, summary judgment. We all know that it's a bedrock principle of civil litigation in both federal and state courts that a plaintiff must plead a viable legal claim. But that's not the case in immigration court, whereas all state and federal courts have tools they can use to dispose of meritless cases at the early stages of litigation. The immigration courts do not. That makes no sense at all. Immigration judges are handcuffed, managing tens of thousands of patently meritless cases from filing to final judgment. On average, an immigration case takes 3+ years from filing to final judgment. By contrast, federal judges are empowered by 12b-6 to dismiss claims that are inadequately pleaded or legally baseless. The courts in all 50 states also have this authority. To determine whether a claim is legally baseless, the court assumes that the facts alleged are true. The court then considers whether those facts satisfy the elements of a viable claim. If the facts as pleaded do not give rise to a viable claim, then the court can dismiss the case. Courts need not wait for a motion to dismiss a meritless case, but in most cases they must give the party whose claims are dismissed an opportunity to be heard. My second point, judgment on the pleadings. Federal Rule of Civil Procedure 12c gives federal district courts the power to grant judgment to a party based solely on the pleadings. Typically, this tool is used when the parties agree on the underlying facts of a case but disagree about their legal effect. Alternatively, as with a dismissal under 12b-6, a court may assume that the facts alleged are true and consider whether they give rise to a viable claim. The courts then apply the law to those facts to determine whether a party is entitled to early judgment. Typically, a party must move for judgment on the pleadings before a court can enter an early judgment. Immigration judges lack both of these tools to prune their dockets. This means that when a plainly meritless case, and there are a lot of them, comes before them, they have no choice but to retain it, manage it, hold hearings on it, and only after the judicial process is exhausted enter the inevitable judgment. The result is judicial gridlock. Meritorious cases stall behind a tsunami of baseless ones. Here's a fact. In FY22, EOIR granted only 14% of asylum claims. In my written testimony, I proposed legislative tweaks to existing immigration statutes that would add 12b-6 and judgment on the pleadings authority to immigration judges. My third point, contempt power. In 2019, the ABA wrote, quote, "Immigration courts are facing an existential crisis and are, quote, irredeemably dysfunctional," unquote, and it's only gotten worse. 26 years ago, Congress passed a law giving immigration judges civil contempt authority, but it delegated it to the U.S. Attorney General to draft the implementing regulations. No administration has done so. As a result, as you've heard, litigants before the immigration courts, government attorneys, and private counsel alike can't be held accountable to the judge with respect to matters such as timelines, docketing dates, or even court orders. Counsel who often carry other cases before non-immigration judge courts, put a priority on cases where the court has actual power to enforce its own orders with either civil or criminal contempt. Counsel who appear before immigration judges know these judges can only wag their fingers and raise their voices if counsel defies a court order, but nothing more. As a result, immigration court judges are treated as second-class judges, taking a backseat to all other judges who have the contempt power over parties and lawyers who knowingly violate court orders. In summary, immigration judges need the same tools that all judges have, first to trim their dockets of meritless cases, and then to manage their existing caseloads and control their courtrooms. Thank you.